Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Hafizul Haris bin Zainuddin. Today I want to review a case that assigned to me by my lecturer, Dr. Suzy. Okay, the case name is Ramli bin Shahdan and another, and Motor Insurance Bureau of West Malaysia and another. The case decided in 2006. We will discuss in this uh, evening the summary of the case, issues, arguments from both parties, court decision, ratio decidendi, analysis, and conclusion. Okay, so let's go to the summary of the cases first. Uh, I have already arranged it in the timeline. And first of all, let we know who is the respondent. On 15 January 1968, the first respondent was the Motor Insurance Bureau, which came into existence via agreement entered into in 1968. The first agreement between the Bureau and the Minister of Transport as the second respondent. Clause 2 of the first agreement will entitle a party injured or killed in a motor accident in whose favor judgment was obtained, the sum payable in respect of the adjudged liability. 1st January 1992, the second agreement between the same parties substituted the first agreement and was deemed to have rescinded the first agreement. Clause 2 of the second agreement, however, gave the Bureau, subject to Clause 10, an absolute discretion to make compassionate payments or allowances to person injured or to dependents of person killed in a motor accident where motor vehicle did not have a valid policy of insurance as required under Part 4 of the Road Traffic Act 1987. Then the case started on 4th May 1995, which Ramli, the first appellant, was riding a motorcycle together with his pillion rider, second appellant, before collided into by a motorcycle that rode by Wong Kon Chah from the opposite direction. Both of the appellants suffered grave injuries. Then on 26 October 1985, unfortunately, the motorcycle used by Wong Kon Chah had no third-party risk coverage at the time of the accident. This is borne out by a letter written by the said Wong Kon Chah to the appellant solicitors. Then, on 6 May 1988, the appellant solicitors accordingly informed the first respondent of its intention to institute proceedings against the uninsured motorcyclist. Then, 6 July 1993, the appellants filed and executed the required claim forms with the first respondent after followed through by a series of correspondence. On 3rd September 1993, judgment was entered against the uninsured rider of the other motorcycle. Then, 11 October 1993 and 12 November 1993 respectively, armed with the judgment, the appellant's solicitors wrote to the first respondent without making reference to the judgment obtained, but instead referred to the claim form sent by the first respondent and requesting an amicable settlement to the matter. Then on 19 November 1993, the first respondent agreed to award a compassionate sum of Rn 8,200 to the first appellant and Rn 4,450 to second appellant. On 27 March 1995, the appellants dissatisfied with the proposal. They both filed this action against the first and second respondents. Okay, so the issues in this case is first, whether the plaintiff have a locus to sue according to privity of contract. Second, whether the first agreement between Motor Insurance Bureau and Ministry of Transportation still valid after entering into second agreement. The arguments from both parties, the appellant stated that they submitted the collision occurred during the tenure of the first agreement and through the correspondent and ensured that they were entitled to the full advantage of the first agreement. Then respondent argued that the appellants were not parties to the first and second agreement and had not given any consideration to the agreement. So the court decided that the appeal dismissed with cause. The cause or the ratio decidendi. First, when a contract was made between first respondent and second respondent for the benefit of the appellants, the second respondent could sue on the contract for the benefit of the appellants and recover all that the appellants would have recovered as of the contract had been made by the appellants themselves. Implicit in this proposition was the fact that if the second respondent failed in his duty, the appellants as beneficiaries under the implied trust may successfully maintain an action against the first respondent and second respondent as joint defendants. Also, this case referred to Gregory and Parker and Williams in 1817, which the Parker owed money to both Gregory and Williams. He agreed with William to assign to him the whole of his property if Williams agreed to pay the debt due to Gregory. But Williams failed to implement his promise. Then Gregory and Parker filed a bill in equity to compel performance of the promise, and they succeeded. The court held that Parker must be regarded as a trustee for Gregory, and Gregory derived an equitable right through the mediation of Parker's agreement. Okay, then the second, from a plain reading of clause 1b of the second agreement, it was apparent that there was an unequivocal intention of both the first and second respondent to mutually rescind the first agreement. The effect of such rescission by mutual agreement was clear. The first contract was extinguished. Also, we can refer this to Section 63 Contracts Act 1950, which stated if the parties to a contract agree to substitute a new contract for it or rescind or alter it, the original contract need not be performed. The third ratio is for the purpose of the agreements in question. What was imperative for purposes of enforcement against the first respondent was a judgment. This was clearly stated in Clause 2 of the first agreement and Clause 2 and 3 of the second agreement. The effective judgment in this respect was dated 3 September 1993, which in effect took the judgment out of the compass of the first agreement that was deemed ineffective at that point of time. The fourth ratio, the submission of the claim forms pursuant to second agreement against the backdrop of correspondence produced by the appellants showed the appellants were in no way laboring under any impression held out by the first and second respondents that they were entitled to the claims under the first agreement. Thus, the submissions of the appellants on estoppel by conduct was a non-starter. Analysis from this case, what is significance of this case? First, the importance of this case to the law of contract. It emphasized the flexibility of doctrine of privity, such as we can see from the court decision. Second, this case shows us how to use Section 63 Contracts Act 1950. 3. To compare this case with another case, which is Beswick and Beswick. This case is about the nephew promised his uncle to pay an annuity to his auntie in consideration of the business of the uncle, in consideration of the uncle transferring the goodwill of the business to the nephew. But unfortunately, nephew failed to fulfill the promise, and the auntie want to file to take an action, but she is not a party. The court held that it could be specifically enforced by the uncle's personal representative, that is auntie, against the nephew. To compare this case with Beswick and Beswick case, this case, the doctrine of privity is excluded due to concept of trust, while the case Beswick and Beswick, the doctrine of privity excluded due to the person is the executory of a party in the agreement. Executory or executrix, the party of a party in the agreement. 4. These cases are too remote. This is just my opinion, but I see that because the cases are too remote, this shows the efficiency of our judicial system is still need to be improved. To conclude, I hope that this case review benefited all of us. Thank you. Assalamualaikum warahmatullahi wabarakatuh.